Before we begin, a quick and important disclaimer. This video provides a historical analysis of the legal and social evolution of divorce practices in the 20th century United States. The information presented is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. Marriage and family laws vary significantly by state and have undergone radical transformations over the last century. Therefore, historical trends and case studies discussed here may not reflect current statutes or outcomes in modern courts. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified, licensed legal professional regarding their specific circumstances. In 1920, if you were a man living in New York and your marriage had become a silent, hollow shell of resentment, you were effectively a prisoner of the state. There was no such thing as falling out of love. There was no such thing as a mutual parting of ways. To the eyes of the law, divorce was not a remedy for a broken relationship. It was a punishment for a crime. If you wanted out, you didn't just need a lawyer. You needed a villain. You had to prove that your spouse had committed a grievous moral failing, and in states like New York, that failing had to be adultery. This led to one of the most bizarre and elaborate underground industries in American history, where men would hire professional actors and photographers to stage fake affairs in hotel rooms just to provide the court with the evidence it demanded. We are talking about a system so rigid that it forced thousands of men into a life of perjury and staged scandals just to regain their freedom. This is the hidden history of how the American man fought, maneuvered, and navigated the most restrictive legal era in modern history. Today, we look at the modern family court system and see a world of no-fault divorce and equitable distribution. But to understand where we are, you must understand the gauntlet your grandfathers and great-grandfathers had to run. This deep dive masterclass is designed to provide you with the historical context of the American divorce experience. By examining the shift from the adversarial fault-based system of the early 1900s to the legislative revolutions of the 1970s, you will gain a profound understanding of why the system carries the biases it does today. We are solving the problem of historical blindness. You will learn the potential outcomes of legal shifts, the data behind the rise of the divorce mill, and the case studies of men who risked their reputations to redefine what it meant to be a provider and a partner. This is not just a history lesson. It is a roadmap of the American masculine experience in the face of institutional collapse. At the dawn of the 20th century, the United States operated under a strict adversarial model of divorce. This meant that every divorce case was structured exactly like a criminal trial. There was an innocent party and a guilty party. There was no middle ground. If both parties wanted the divorce, the law often viewed that as collusion, which was a crime in itself. If a judge suspected that a husband and wife were working together to end their marriage, he could, and often would, deny the divorce entirely, forcing them to remain legally bound for life. For the American man in 1905, this meant that seeking a divorce was an act of high-stakes legal warfare. You had to prove one of the statutory grounds, which typically included adultery, physical cruelty, or willful desertion. Consider the case study of the fault era in New York. Because adultery was the only acceptable ground for decades, a shadowy industry of professional correspondence emerged. A man seeking a divorce would hire a young woman, the correspondent, to meet him at a hotel. They would check in, the woman would change into a robe, and then at a prearranged time, a hired photographer and a private investigator would burst into the room to take a photo of the two of them together. These photos were then presented in court as proof of infidelity. This wasn't a secret. It was an open narrative that everyone from the judges to the janitors knew was a sham. Yet the law required the performance. The psychological and financial toll on men during this era was immense, as they had to navigate the social stigma of being labeled an adulterer or a degenerate just to escape an abusive or dead-end union. Data from the early 1900s shows that despite these barriers, the demand for divorce was skyrocketing. In 1890, there were only about 33,000 divorces in the entire United States. By 1920, that number had jumped to over 170,000. This created a massive supply and demand problem. If your home state made it impossible to leave, you had to find a loophole. This led to the rise of the migratory divorce. For a man with the financial means, the solution was not to fight the local courts, but to leave them. This is where the legend of Reno, Nevada begins. In the 1930s, Nevada realized they could capitalize on the restrictive laws of other states. They lowered their residency requirement to just 6 weeks. If a man could afford to leave his job and live in a Nevada divorce ranch for 42 days, he could be granted a decree that was legally binding across the country. This Reno cure became a cultural phenomenon. It was the first time we saw a consumerist approach to family law. Men would travel by train to the desert, spend their days riding horses and playing cards, and then walk into a courtroom to be cleansed of their marital obligations. However, this was a luxury reserved for the upper class. For the working class man, the 20th century offered no such escape. He was often left with only two choices: remain in a miserable household or disappear. This led to a massive spike in the poor man's divorce, otherwise known as desertion. Historical trends show that thousands of men simply walked out the door and started new lives in different states under different names, leaving the legal system to grapple with a crisis of abandoned families. Step by step, the legal pressure cookers of the early century began to hiss. The tension between the Victorian ideal of marriage for life and the modern reality of marriage for happiness was reaching a breaking point. Men were no longer content to be just the breadwinner in a loveless contract. They were beginning to seek emotional fulfillment. But the law was a lagging indicator. Even as we moved into the 1940s and 1950s, the concept of alimony remained a punishment for the guilty party. If a man was found at fault for the end of the marriage, he was often ordered to pay permanent alimony, a financial obligation that lasted until the ex-wife remarried or died. In an era where women were largely excluded from the workforce, this was seen as a necessary social safety net. But for the man, it often meant a lifetime of financial servitude to a ghost. As we move deeper into this masterclass, we will look at how the post-World War II era accelerated these tensions. The 1950s are often romanticized as the era of the perfect family, but the historical data tells a different story. The greatest generation returned from war with a different perspective on life and time, and the divorce rates reflected a growing desire for personal autonomy that the 19th century laws simply couldn't contain. We are going to break down the specific legislative battles, the rise of the father's rights precursors, and the social shifts that led to the eventual no-fault explosion. This is the foundation. You cannot understand the complexities of modern support payments, custody battles, or asset division without first understanding the fault system that modern laws were designed to dismantle. We are peeling back the layers of a century of struggle to show you exactly how the American man moved from the staged affair to the modern mediation table. Stick with us because the evolution of the mid-century is where the real drama and the real lessons begin. The year is 1946. Imagine you are a man named Robert, returning to a quiet suburb in Ohio after 3 years in the Pacific Theater. You are not the same man who left, and your wife is not the same woman who waved goodbye. The silence in your kitchen is heavier than the sound of artillery. You both know the marriage is a hollow shell, but in 1946, knowing a marriage is over and legally ending it are two entirely different universes. For Robert, the law does not care about his soul-crushing unhappiness or the fact that both he and his wife want a fresh start. The law only cares about guilt. To understand the mid-century experience for men, you have to grasp the concept of the permanent record. In the 1940s and 1950s, a divorce was not a private family matter. It was a public indictment. If Robert wanted to leave, he had to prove his wife had committed a crime against the marriage, or he had to volunteer to be the criminal himself. This era created a massive psychological burden for the American man. If he took the blame to spare his wife's reputation, he faced the very real potential outcome of being barred from certain social clubs, losing his standing in the church, or being passed over for promotions at his firm because he was now a man of questionable character. Historical trends during the post-war era show a massive spike in divorce filings that the legal system was utterly unprepared to handle. Between 1940 and 1946, the divorce rate in the United States nearly doubled. This was the first major stress test for the adversarial system. Men were finding themselves in a trap where the only way out was through the mud. Let's look at a case study from 1952. A man we will call James, a mid-level manager in Detroit, found himself in a marriage defined by what was then called habitual intemperance. In 1952, James couldn't just cite irreconcilable differences. He had to bring witnesses, neighbors, friends, even his own children, to testify in open court about the most intimate and painful details of his domestic life. The step-by-step process of a 1950s divorce was designed to be as humiliating as possible to discourage people from following through. It was a system of social control disguised as legal procedure. This brings us to the financial engine that powered the mid-century divorce machine: alimony. In today's world of 2026, We see alimony as a rehabilitative tool meant to help a lower-earning spouse get back on their feet. But in the 1950s, alimony was often a life sentence. Because the law viewed the husband as the sole provider, and the wife as a legal dependent, a man's financial obligation did not end with the marriage certificate. It was common for a man to be ordered to pay a fixed percentage of his income to his ex-wife for the rest of her life, or until she remarried. Imagine the reality for a man in 1958 who earns a respectable salary but sees 40% of every paycheck vanish before it touches his hand, all to support a woman he hasn't spoken to in 5 years. This created what historians call the alimony jail era. In states like New York, if a man fell behind on his payments, even if he lost his job or suffered a medical emergency, he could be held in civil contempt and thrown into a literal jail cell. These were not hardened criminals. These were accountants, mechanics, and salesmen who simply could not keep up with the court's rigid financial demands. There were actually alimony clubs formed inside these jails where men would gather to share legal strategies and commiserate over their shared financial ruin. This was the hidden dark side of the mid-century American dream. The social pressure for men to maintain the facade of the happy nuclear family was immense. This is why we see the rise of the desertion phenomenon during this period. For many men, the legal and financial cost of a formal divorce was so high that they chose a path of total erasure. They would pack a suitcase, drive to a different state, change their name, and start over from scratch. Historical data suggests that tens of thousands of men in the mid-20th century became ghosts in their own lives because the legal system offered no dignified path for exit. By the time we hit the early 1960s, the tension began to shift from the courtroom to the cultural consciousness. Men were starting to question why the law treated them as nothing more than an ambulatory bank account. Case studies from this era show the beginning of a quiet rebellion. Men started seeking out lawyers who specialized in finding technicalities to void marriage contracts entirely. Annulments became the weapon of choice for the clever. If you could prove the marriage was fraudulent from the beginning, perhaps claiming your spouse had no intention of having children when they said they did, you could wipe the slate clean and avoid the alimony trap. However, the burden of proof remained a mountain. Imagine being a man in 1963 trying to prove your spouse's mental cruelty. You would have to document every argument, every cold shoulder, and every perceived slight, and then present it to a judge who likely viewed divorce as a moral failing regardless of the evidence. The legal standard of extreme cruelty was intentionally vague, giving judges massive discretionary power. If a judge didn't like your tone or your haircut, he could deny your petition, leaving you legally bound to a person who despised you. We also have to look at the role of the private investigator during this era. In the 1950s and 60s, the PI was the shadow king of the divorce courts. Men were frequently followed, their trash was searched, and their phone lines were tapped. If a man was even suspected of having a girlfriend before the divorce was finalized, he lost everything. The potential outcomes were binary. You were either the innocent provider or the guilty lecher. There was no room for the complexity of human relationships. As we move into the late 1960s, the cracks in this rigid system started to become canyons. The 1960s weren't just about rock and roll and political protests. They were about the fundamental reassessment of the individual's relationship with the state. Men were returning from a different kind of war in Vietnam, and finding that the domestic laws of their fathers no longer made sense in a world that was rapidly deconstructing traditional gender roles. But there was one specific event, one legislative earthquake in California, that would change the trajectory of every man's life in America. It was a move that promised to end the era of staged affairs and alimony jails forever. But as we will see, it created a whole new set of challenges that men are still navigating in 2026. This shift didn't just change the rules of the game. It changed the game itself. In the next part of this deep dive masterclass, we are going to look at the 1969 revolution. We will examine the exact moment the fault system collapsed and the era of no-fault divorce began. You will see how a future president of the United States signed a bill that he would later call one of his greatest regrets. Why did the solution to the 1950s trap become the crisis of the 1970s? What happens to a man's rights when the court no longer cares who did what to whom? The shift from the courtroom drama to the cold math of the 1970s is where the modern landscape of family law was truly born, and you cannot afford to miss the data we are about to break down. The year 1969 stands as the most significant turning point in the history of American domestic relations. If you were a man living in California that year, you were standing at the epicenter of a legal earthquake. Governor Ronald Reagan signed the Family Law Act into existence, and with the single stroke of a pen, the centuries-old framework of fault-based divorce was dismantled. To understand the gravity of this shift, imagine you are a man named Michael living in Los Angeles in 1970. Under the old system, if Michael's wife wanted a divorce, she had to prove he was a bad actor, an adulterer, a deserting husband, or a man of extreme cruelty. If Michael had been a faithful provider and a loyal spouse, he could essentially block the divorce. He had legal standing to keep his family together or, at the very least, use his innocence as leverage during financial negotiations. But when no-fault divorce arrived, the rules of engagement for men like Michael changed overnight. The new standard became irreconcilable differences. This legal term effectively meant that if one person felt the marriage had broken down irretrievably, the court was required to grant the dissolution. For the first time in United States history, divorce became unilateral. Michael no longer had a defense. There was no way to plead his case that the marriage was worth saving. The court was no longer interested in who was at fault. It was only interested in the administrative process of ending the contract. This was a radical departure from the idea of marriage as a sacred, permanent covenant protected by the state. It transformed marriage into a civil contract that could be terminated by either party at any time, for any reason, or for no reason at all. Historical trends immediately reflected this massive policy shift. In the decade following California's adoption of no-fault, the divorce rate in the United States surged to unprecedented levels. By the mid-1970s, the number of divorces in the U.S. surpassed 1 million per year for the first time. This period is often referred to by historians as the Great Divorce Wave. For the American man, this was a time of profound disorientation. The potential outcomes of a divorce filing were no longer tied to his conduct. Even if he did everything right, worked 40 hours a week, stayed faithful, and maintained the home, he could still find himself served with papers and moved out of his house within weeks. Let us look at a case study of the financial transition during this era. In the fault-based system, alimony was often used as a tool of equity. If a man was the innocent party, he rarely had to pay alimony. If he was the guilty party, he paid a heavy price. However, as no-fault spread across the states like a line of falling dominoes, the logic of alimony shifted. Courts began to move toward the concept of equitable distribution or community property. Imagine Michael again in 1972. The court didn't care that he hadn't wanted the divorce. Instead, the judge looked at the math. Everything Michael had earned during the marriage was now viewed as a joint asset to be split down the middle. This sounds fair on paper, but for many men in the 1970s it felt like a double blow. They lost the legal right to fight for their marriage, and then they lost half of the assets they had built under the assumption that the marriage would be permanent. The step-by-step reality of a 1970s divorce hearing became cold and clinical. Gone were the dramatic testimonies of private investigators and the high-stakes cross-examinations of the 1950s. Instead, the hearings became short, administrative sessions. A man would walk into a courtroom, the judge would confirm that the parties had lived apart for the required statutory period, which many states were rapidly shortening, and the decree would be signed. This efficiency was marketed as a way to reduce the bitterness and perjury of the old system, which it did. But it also introduced a new kind of trauma, the trauma of the disposable marriage. Men began to realize that the legal protection they thought they had as heads of household was an illusion. Ronald Reagan would later reflect on signing this bill as one of the biggest mistakes of his political career. The intent was to bring honesty to the court and stop the staged hotel room scandals we discussed in the previous part of this series. But the unintended consequence was the total destabilization of the family unit as a legal entity. Data from the 1970s shows a significant rise in what sociologists call the feminization of poverty, but it also shows a corresponding rise in the social and psychological isolation of men. As marriages ended more quickly and with less legal friction, many men found themselves alienated from their social circles and, most critically, their children. This brings us to the most painful chapter of the 1970s transition, the custody battle. While the laws of property were becoming more gender-neutral with the rise of equitable distribution, the laws of custody remained firmly rooted in the tender years doctrine. This was a judicial bias that presumed young children were best left in the care of their mothers. Imagine if Michael, our 1970s father, wanted to be a primary parent. Even though the divorce wasn't his fault and even though he was a dedicated father, the legal system of the 1970s almost always relegated him to the role of a weekend visitor. The potential outcomes for fathers during this decade were bleak. They were often viewed by the courts as nothing more than a walking child support check. In states like New York and Illinois, which were slower to adopt full no-fault laws, Men lived in a bizarre dual reality. They saw the freedom of men in California and Nevada, while they were still trapped in the old world of proving adultery. This created a geographical inequality in the United States. A man's rights and his financial future depended entirely on which side of a state line he lived on. We see case studies of men in the mid-70s literally moving their entire lives and businesses to different states just to access more favorable divorce statutes. This was the era of the strategic relocation, a desperate attempt to find a legal environment that didn't feel inherently rigged against the male provider. The 1970s also saw the birth of the modern child support enforcement complex. As divorce became easier to obtain, the state became more concerned about the rising costs of welfare for single mothers. This led to federal interventions like the Social Security Act amendments of 1975, which created the Office of Child Support Enforcement. For the first time, the federal government was getting involved in the collection of private domestic debts. For the American man, this meant that his private life was now a matter of federal record. The step-by-step enforcement of these payments became increasingly aggressive, with the threat of wage garnishment and tax refund interception. As the decade drew to a close, the American man was living in a completely different landscape than his father had. The old world of fault, shame, and stage scandals was gone, replaced by a new world of unilateral exits, 50-50th splits, and the tender years doctrine. But as men began to adjust to this new reality, a new movement was brewing. They began to realize that if the laws of marriage had changed, the laws of fatherhood needed to change too. They were tired of being weekend visitors. They were tired of the presumption that they were secondary parents. What happened when these men started to organize? What happened when the first fathers' rights groups began to walk the halls of state legislatures in the late 1970s and early 1980s? We are about to look at the era of the counterstrike. We will dive into the specific legal battles that challenged the tender years doctrine and the introduction of the concept that would change the 1980s forever: joint custody. But as we will see, this victory for men came with a set of complications and costs that no one saw coming. The battle for the 1980s was about to get much louder, and the data behind the rise of the joint custody movement reveals a story of grit, strategy, and a fundamental shift in what it meant to be a father in America. You need to see how these men fought back, because the tactics they used in the 1980s are the very same ones that shaped the laws you live under in 2026. As the calendar turned from the 1970s into the early 1980s, the American man found himself in a legal no man's land. The previous decade had stripped away his ability to defend his marriage through the no-fault revolution, but it had not yet granted him the right to remain a primary parent. For a father in 1980, the legal reality was defined by a ghost of the Victorian era: the tender years doctrine. This judicial presumption held that during a child's tender years, typically defined as anything under the age of 13, the mother was naturally and biologically better suited to provide care. For a man, this meant that unless he could prove his wife was a total moral failure or physically dangerous, he was mathematically certain to lose primary custody. He was being ushered out of the home and into the role of a weekend visitor, a role that came with a heavy financial price tag, but almost no legal authority. Imagine a man named David in 1982. David is a civil engineer in Chicago. He has spent every evening of the last 5 years bathing his kids, reading them stories, and coaching their t-ball games. But when his marriage dissolves in the early 80s, David walks into a courtroom where the judge still views him through a 1950s lens. To the court, David is a paycheck with a pulse. The judge looks at the tender years doctrine and assumes that David's role is to provide the capital, while the mother provides the care. David is told he will see his children every other weekend and for 2 weeks in the summer. He is devastated. He is not just losing a spouse, he is being demoted in the lives of his own children. This was the catalyst for the second great shift of the 20th century: the rise of the fathers' rights movement and the legislative push for joint custody. The historical trends of the early 1980s show a massive grassroots uprising of men like David. They began to realize that if the law was going to be gender-neutral regarding who could end a marriage, it had to be gender-neutral regarding who could raise the children. The first major crack in the dam occurred in California, again the trendsetter, which in 1979 passed the first law in the United States that established a presumption that joint custody was in the best interest of the child. This was a revolutionary concept. It moved the goalposts from maternal preference to a standard known as the best interests of the child. Step by step, men in the 1980s had to learn a new kind of legal warfare. They were no longer hiring private investigators to catch wives in hotel rooms. They were hiring child psychologists and social workers to testify about their parenting skills. For David in 1982, this meant a grueling process of home inspections and interviews. He had to prove to a skeptical court that he knew his children's shoe sizes, their teachers' names, and their medical histories. He had to document every hour spent parenting. This era saw the birth of the parenting log, a tool men used to fight the assumption that they were secondary parents. The potential outcomes of these cases began to shift. By 1984, over 30 states had followed California's lead and passed some form of joint custody legislation. However, this shift created a new set of financial complexities. In the old system, child support was a straightforward calculation. The man paid because the woman had the kids. In the new world of the 1980s, where joint custody was becoming a possibility, the math became a battlefield. Men argued that if they had the children 50% of the time, they should not be paying 100% of the support. This led to the development of complex child support guidelines. Historical trends show that during the mid-80s, states began to adopt standardized formulas to take the guesswork and the individual bias of judges out of the equation. But these formulas often created a cliff effect. If a man had his kids for 39% of the time, he paid full support. If he hit 40%, the payment might drop significantly. This turned the clock into a financial instrument. Every hour of visitation was now worth a specific dollar amount, adding a layer of cold, calculated tension to an already emotional situation. This was also the era of the Kramer versus Kramer effect. The 1979 film had a profound impact on the American public's consciousness. It was the first time a mainstream narrative showed a father struggling with, and succeeding at, the daily grind of single parenthood while the mother was the one who walked away. This cultural shift gave men like David the social permission to demand more. They were no longer ashamed to want to be the primary caregiver. Case studies from this era show a spike in men seeking sole custody, not out of spite, but out of a genuine belief that they were the more stable parent. This was a direct challenge to the fundamental social architecture of the United States. But as men gained ground in the custody arena, the state was tightening its grip on the financial side. The 1984 Child Support Enforcement Amendments were a federal response to the growing number of single-parent households. The federal government began requiring states to use wage withholding for child support and to improve their procedures for establishing paternity. For the American man, the 1980s were a decade of contradiction. He was finally being recognized as a parent in the eyes of the law, but he was also being tracked by the state with unprecedented efficiency. If you were a man in 1986 and you fell behind on your payments, the state no longer needed to throw you in an alimony jail. They could simply take the money directly from your employer before you ever saw it. The step-by-step evolution of the 1980s also introduced a new player in the divorce drama: the guardian ad litem. This was a person appointed by the court to represent the child's interests independently. For a man fighting for custody, the guardian ad litem was the ultimate gatekeeper. If this person, who often had their own subconscious biases, didn't believe a father should have 50-50 custody, the battle was almost over before it began. Men had to learn to navigate this new bureaucracy, often spending thousands of dollars on expert witnesses to counter the reports of court-appointed evaluators. By the end of the 1980s, the legal landscape had been transformed. The tender years doctrine was dead on paper, though it lived on in the hearts of many judges. Joint custody was the new gold standard, and the best interests of the child was the law of the land. Men had fought their way back into the home, but they had done so by entering a system that was more bureaucratic, more expensive, and more intrusive than anything their fathers had faced. They were no longer just husbands or providers, they were litigants in a permanent state of oversight. But just as men were adjusting to this new world of joint custody and wage withholding, the 1990s arrived with a whole new set of challenges. The next decade would see the rise of the digital age, which changed how evidence was gathered and how families were monitored. It would also see the introduction of even more aggressive enforcement tactics, and a shift in the way domestic allegations were handled in court. What happens when the battle for the children moves from the kitchen table to the computer screen? What happens when a new set of laws designed to protect start to be used as strategic weapons in the divorce wars of the 1990s? We are about to dive into the era of the silver bullet and the rise of the high-conflict divorce, where the stakes for men reached a terrifying new high. Entering the 1990s, the American legal landscape for men underwent a shift that was as quiet as it was devastating. We moved away from the loud public debates of the 1970s and 80s and into an era of high-tech surveillance and tactical legal maneuvers. This was the decade of the silver bullet. In the specialized world of family law, the silver bullet referred to a specific strategy: the use of an ex parte temporary restraining order to immediately remove a man from his home and sever his contact with his children without a prior hearing. To understand the gravity of this, imagine a man named Mark in 1994. Mark is a project manager living in a suburb of Atlanta. He has no criminal record, no history of violence, and has never been a threat to his family. One Tuesday evening, Mark pulls into his driveway to find a sheriff's deputy waiting for him. Within 5 minutes, Mark is told he has 15 minutes to pack a single bag and leave the premises. He is informed that he cannot contact his wife or his children until a hearing is held, a hearing that might not happen for 3 weeks or more. This was the hallmark of the 1990s experience for thousands of American men. The legal threshold for obtaining these orders began to drop significantly. Under the prevailing logic of the time, judges preferred to err on the side of caution. If a spouse claimed she felt unsafe or alleged a vague threat, the court's default response was to grant the order first and ask questions later. For Mark, the potential outcomes were catastrophic. By the time he finally got his day in court 21 days later, his wife had established a 3-week status quo as the sole caregiver and the sole occupant of the family residence. In the eyes of the 1990s family court, 3 weeks was an eternity. The court was hesitant to disrupt the children's new routine, effectively handing the wife a massive advantage in the upcoming custody battle. This was not a move based on safety. It was a move based on litigation strategy, designed to checkmate the man before the game had even begun. The historical trends of this decade were heavily influenced by the passage of the Violence Against Women Act of 1994, or VAWA. While the intent of the legislation was to provide critical resources for actual victims of domestic abuse, its implementation in the civil arena of family court created unintended consequences for men. Data from the mid-90s shows a significant correlation between the filing of a divorce and the simultaneous filing of a restraining order. For the American man, the step-by-step reality of a divorce now included a defensive posture against what many attorneys openly called tactical allegations. Men had to learn to live under a microscope. They were advised by the first wave of internet-based support groups to never be alone with their spouse once a divorce was mentioned, to keep a microcassette recorder in their pocket at all times, and to document every interaction with meticulous detail. This era also saw the weaponization of the deadbeat dad narrative. In 1992, Congress passed the Child Support Recovery Act, followed by the 1996 Welfare Reform Act under the Clinton administration. These laws were fueled by a massive public relations campaign that painted divorced men as financial fugitives. The state's rhetoric was clear. The primary cause of childhood poverty was the failure of fathers to pay child support. While there were certainly men who evaded their responsibilities, the historical data suggests a much more complex reality. Many of the men labeled as deadbeats were actually dead broke dads. Men who had lost their jobs during the early 90s recession or whose child support orders were based on high salaries they could no longer earn. The step-by-step enforcement became increasingly draconian. In 1996, the Personal Responsibility and Work Opportunity Reconciliation Act established the National Directory of New Hires. This was a massive federal database that tracked every person who started a new job anywhere in the United States. If a man moved from New York to Texas to find work, the system caught him within days and automatically initiated wage garnishment. For men like Mark, this meant that the state had more power to collect his money than he had to see his children. The disconnection between the right to parenting time and the obligation of payment became a gaping wound in the American male psyche. The law treated these as two separate tracks. You must pay regardless of whether you are allowed to see your children. Yet if you don't pay, the state can take your driver's license, your professional license, and eventually your freedom. As the 90s progressed, we also saw the rise of parental alienation syndrome as a term entering the courtroom lexicon. First coined by Dr. Richard Gardner, this concept described a process where one parent systematically brainwashes a child against the other. For many fathers in the 90s, this was the only explanation for why their children, who had once been close to them, suddenly refused to speak to them or expressed irrational hatred toward them. Imagine the psychological toll on a man who had spent the 1980s fighting for joint custody, only to find himself in 1998 being treated like a stranger by his own son. Case studies from this era show a terrifying trend of high-conflict divorces where children were used as foot soldiers in a war of attrition. The legal system was often ill-equipped to handle this psychological warfare, usually siding with the parent who had primary physical custody under the assumption that the child's stated preference, no matter how coached, was paramount. The 1990s also introduced the first generation of digital evidence. Before smartphones and social media, we had pagers, early cell phones, and the first iterations of email. Men were caught off guard by how their digital footprints could be used against them. A pager message sent in a moment of frustration or a poorly phrased email could be printed out and presented to a judge as evidence of an unstable temperament. The privacy that men once enjoyed during the divorce process was evaporating. Every communication was now a potential exhibit. This led to the birth of the gray rock strategy long before it had a name. The idea that a man must become as boring and unresponsive as a rock to avoid providing any ammunition for the opposing side's narrative. By 1999, the American man was navigating a legal system that had become a high-stakes administrative machine. The era of the simple no-fault split was over, replaced by a world of tactical restraining orders, federal tracking databases, and psychological alienation. Men were realizing that being a good father and a good provider was no longer enough. They had to be legal experts, digital archivists, and psychological warriors just to maintain a basic relationship with their children. But as the clock ticked toward the new millennium, a new crisis was brewing. The year 2000 would bring a technological revolution that would make the surveillance of the 90s look like child's play. We were about to enter the era of the digital divorce, where social media, GPS tracking, and the total transparency of a man's life would change the rules once again. What happens when your entire life is stored on a device that can be subpoenaed? How did the rise of the internet transform the father's rights movement from a fringe group of activists into a global powerhouse? And more importantly, how did the shift in the early 2000s create the specific legal traps that men are still falling into today in 2026? We are about to look at the transition into the 21st century, where the battle for a man's future moved from the courtroom to the cloud. As we cross the threshold into the year 2000, the American man found himself entering a digital panopticon that would forever alter the mechanics of divorce. The transition from the 20th to the 21st century was not just a calendar change. It was the birth of the era of the electronic trail. To understand the gravity of this shift, imagine a man named Christopher in the year 2002. Christopher is a software consultant in Northern Virginia. He is going through a contested divorce, and like many men of his era, he believes that his private thoughts shared via email or his personal browsing habits are ephemeral. He believes that if he deletes a message, it is gone. He is tragically mistaken. In the early 2000s, the legal concept of discovery underwent a radical expansion. Lawyers were no longer just asking for boxes of bank statements and tax returns. They were demanding mirror images of hard drives and access to early server-side backups. This was the dawn of e-discovery. For Christopher, the step-by-step process of a digital audit became a psychological gauntlet. His wife's legal team hired forensic data experts who combed through his AOL Instant Messenger logs and his work emails from 1999. They weren't just looking for evidence of an affair. They were looking for metadata. They wanted to see if he was researching assets, if he was venting to friends about his desire to hide income, or if his tone in private messages contradicted his calm demeanor in the courtroom. This created a new potential outcome for men: the digital character assassination. In the 1980s, your reputation was based on what neighbors saw or what you said in person. By 2002, your reputation was a composite of every keystroke you had made over the previous 5 years. Historical trends during this transition show a massive surge in the use of forensic accounting. In the old world, a man might try to hide cash under a mattress or in a secondary bank account. In the world of the early 2000s, every financial transaction left a digital footprint. Case studies from this period highlight the emergence of the lifestyle audit. Imagine Christopher claiming in court that he can only afford $800 a month in child support because his consultancy business is struggling during the post-9/11 economic downturn. However, his digital footprint reveals something else. A forensic accountant tracks a series of small, recurring payments to a high-end golf club or a digital subscription for a luxury car magazine. Individually, these are minor. Collectively, they are used by the court to establish that Christopher's actual standard of living is much higher than his reported income suggests. The court then imputes income to him, meaning they set his support obligations based on what they believe he could earn, rather than what he claims to be earning. This period also saw the rise of the social media trap. Before Facebook and Instagram dominated the landscape, there was Friendster and MySpace. Men, unaware of the emerging dangers, began to post their lives online. A man might post a photo of himself at a bachelor party or holding a drink at a backyard barbecue. In the context of a custody battle, these photos were stripped of their nuance and presented to a judge as evidence of an unstable lifestyle or a lack of focus on parenting. Step by step, the private life of the American man was being harvested for the purpose of litigation. The strategy for attorneys changed from finding the smoking gun to building a mountain of digital pebbles that, when piled high enough, would bury a man's credibility. The early 2000s also brought a hardening of the financial infrastructure. The 1996 Welfare Reform Act had already set the stage, but by 2004, the automation of child support enforcement was nearly absolute. The state systems were now fully integrated with banking institutions. If Christopher fell behind on his payments, the system didn't wait for a human being to file a motion. It automatically triggered a freeze on his bank accounts and a suspension of his driver's license. This created a paradoxical situation for many men. The state would take away their ability to drive to work as a punishment for not having enough money to pay the state. This cycle of debt and license suspension became a defining feature of the early 21st century divorce experience, particularly for middle-class men who lacked the liquid capital to weather a sudden financial shock. Furthermore, the psychological impact of being watched 24/7 led to a rise in what historians call the digital defensive posture. Men began to realize that their cell phone records could be subpoenaed to show their location at any given time. If Christopher told the court he was home with his children but his cell tower ping showed he was at a bar 3 miles away, his credibility was shattered. This led to a level of self-censorship that was unprecedented. Men were advised by their counsel to stop using email, to stop texting, and to return to a world of oral communication. But even that wasn't safe, as the 2000s also saw the proliferation of small, inexpensive digital recording devices. The era of the hidden recorder had arrived. Consider the case study of a mid-level executive in 2005 who lost his primary custody claim because his ex-spouse had surreptitiously recorded their phone calls for 6 months. In many states, this was a legal gray area or even a violation of wiretapping laws. But in the chaos of family court, these recordings often made their way to the judge's ears under the guise of showing the father's true nature. One angry outburst in a 30-minute call, edited down to a 10-second clip, could define a man's entire parenting capacity in the eyes of a busy judge. The American man was no longer just fighting a legal battle. He was fighting a PR war where the other side had all the footage. As the decade progressed toward 2010, the cloud began to emerge. The transition from physical hard drives to remote servers meant that a man's data was no longer even in his own house. It was everywhere. This total transparency created a new form of high-conflict divorce. The battle moved from who gets the house to who gets the passwords. The struggle for control over digital assets, family photo archives, and even shared Amazon accounts became the new front line. Men were finding that their entire digital legacy could be held hostage or wiped out with a single click. But while the digital world was closing in, a new movement was taking root in the physical world. Men were beginning to share their stories in online forums, creating the first truly global network of divorce support. They were exchanging strategies on how to survive the digital audit and how to counter the tactical allegations of the 1990s. This collective intelligence was starting to produce a new kind of litigant, the informed, prepared, and technologically savvy father. However, just as men were learning to navigate the digital panopticon, the legal system was preparing its next evolution. We were about to enter a period where the very definition of a parent would be challenged, and where the rise of a new kind of psychological warfare would take center stage. What happens when the court stops looking at your hard drive and starts looking at your brain? What happens when the most dangerous weapon in a divorce isn't a recorded phone call, but a professional diagnosis? We are about to dive into the era of the psychological evaluation and the rise of the parental alienation expert, where the stakes move from your wallet to your mind. The next chapter of this deep dive masterclass will reveal how the mid-2000s turned the family court into a laboratory of human behavior, and the results for men were more complex than anyone could have predicted. By the mid-2000s, the courtroom had transformed into a psychological laboratory, and the American man was the primary subject under the microscope. This era saw the institutionalization of the custody evaluation, a process so invasive and complex that it made the private investigators of the 1950s look like amateurs. To understand the gravity of this shift, we must look at the case of Christopher in 2026, reflecting on the precedents set during this pivotal transition. Christopher is not just fighting a legal battle over assets, he is fighting a clinical battle over his own personality. In the late 20th and early 21st centuries, the family court system moved away from simple legal arguments and toward a model of behavioral science. This led to the rise of the 730 evaluation in states like California, or the social study in states like Texas. These were not mere interviews, they were full-scale forensic audits of a man's psyche. Imagine the step-by-step reality for a man entering this process. First, you are ordered by a judge to undergo a battery of psychological tests. The most common among these is the MMPI-2, or the Minnesota Multiphasic Personality Inventory. This test consists of over 500 true or false questions. It is designed to screen for clinical disorders, but in the context of a divorce, it becomes a weaponized diagnostic tool. A man might be asked questions like, "Do you ever feel like people are talking about you? Or do you enjoy mechanics magazines?" To the average man, these seem like throwaway questions. But to a forensic psychologist, they are part of a sophisticated scoring system. If you answer in a way that suggests you are trying to present yourself too perfectly, you trigger what is called the L scale or the lie scale. If the L scale score is too high, the entire test is flagged, and the evaluator may report to the judge that you are being defensive or manipulative. For the American man, this creates a double bind. If you are honest about your stress, you are labeled as unstable. If you try to appear stoic and capable, you are labeled as deceptive. Historical trends show that during the 1990s and 2000s, the use of these evaluations increased by over 300% in contested cases. This created a massive, lucrative industry of expert witnesses. The financial potential outcomes for men were devastating. A full custody evaluation during this period could cost anywhere from $5,000 to $50,000, and in most cases, the court would order the higher-earning spouse, historically the man, to pay the lion's share of the fee. You were essentially being forced to pay for the very person who might recommend that you only see your children 4 days a month. This was the professionalization of the best interests of the child standard, a standard so vague that it allowed evaluators to insert their own cultural and gender biases into their final reports. The evaluation process itself was a masterpiece of surveillance. Step by step, the evaluator would conduct home visits. Imagine Christopher in his apartment, trying to act natural while a court-appointed psychologist sits in the corner of the living room with a clipboard, watching him make a sandwich for his son. The evaluator is looking for everything. Is the fridge stocked? Are there enough toys? Is the father too soft or too harsh? The psychological pressure of being observed in your own home by a stranger who holds the power to take your children away is a trauma that an entire generation of divorced men has carried. The evaluator would then conduct collateral interviews, calling Christopher's boss, his children's teachers, and even his neighbors. In the 20th century, your reputation was a social asset. In the 21st century divorce, your reputation became a data point in a forensic report. Data from the early 2000s suggests that judges followed the recommendations of these custody evaluators in over 80% of cases. This effectively moved the power of the bench to the office of the psychologist. If the evaluator's report was biased or based on a flawed interpretation of the testing, the man's legal team had to spend thousands more on a rebuttal expert just to challenge the findings. This led to the era of the battle of the experts. A divorce was no longer about who was right or wrong. It was about whose paid expert was more convincing to a judge who was often too overworked to read the full 100-page report. We must also examine the shift from fault to fitness. In the early 20th century, a man was judged on his moral conduct. Did he drink? Did he gamble? In the late 20th century, he was judged on his psychological fitness. This introduced a new kind of tactical allegation, the mental health smear. It became common practice for an opposing party to allege that the father suffered from narcissistic personality disorder or anger management issues. These were not just insults. They were strategic moves to trigger a court-ordered evaluation. Once that door was opened, the man was on the defensive for the remainder of the litigation. He was no longer a father. He was a patient under review. Case studies from this era highlight the emergence of the parenting coordinator. This was a new type of quasi-judicial officer who could make binding decisions on day-to-day parenting disputes. If Christopher and his ex-wife couldn't agree on which parking lot to use for a child exchange, the parenting coordinator would decide, and they would bill Christopher by the hour for that decision. This added another layer of bureaucracy and expense to the man's life. The state was no longer just a referee. It was a permanent co-parent. The autonomy of the American father was being eroded by a system that claimed to be protecting children, while simultaneously draining the resources that those children needed for their future. The psychological era also saw the rise of the parental alienation narrative as a two-edged sword. While it provided a name for the behavior of parents who sought to destroy the bond between a child and the other parent, it was also frequently used to dismiss a father's legitimate concerns about his children's welfare. If a man pointed out that his children were being coached to fear him, he was often accused of being the alienator himself. The complexity of these psychological dynamics required a level of legal sophistication that most men simply didn't have at the start of their cases. They were walking into a high-tech psychological war with 19th-century expectations of fairness. By the time we reached the end of the first decade of the 2000s, the transformation was complete. The American man was living in a world where his finances were tracked by federal databases, his movements were monitored by GPS and cell tower pings, and his very thoughts were being analyzed by court-appointed experts. He was the most scrutinized demographic in the history of the United States legal system. The cost of entry into the world of fatherhood, should a divorce occur, had become a lifetime of surveillance and financial obligation. But as this psychological laboratory reached its peak, a new and even more dangerous phenomenon began to emerge. It was a strategy that would combine the tactical restraining orders of the 1990s with the high-tech surveillance of the 2000s. It was a move that could end a man's custody, his career, and his reputation in a single afternoon. In the next part of this deep dive masterclass, we are going to look at the rise of the domestic violence industry and the strategic use of orders of protection as a tool of litigation. We will examine the data behind the skyrocketing number of filings and how the definition of abuse was expanded to include things no one would have imagined in 1950. What happens when the court's shield becomes the lawyer's sword? You are about to see the darkest chapter of the 20th century legal evolution and the specific steps men took to survive it. To understand how the American man's experience in the legal system reached its most precarious state, we have to examine the evolution of the order of protection. In the middle of the 20th century, a restraining order was a rare and gravity-laden criminal remedy, usually reserved for situations of clear, documented physical danger. However, as we transitioned into the 1990s and early 2000s, this legal tool underwent a radical metamorphosis. It shifted from a shield designed to prevent physical harm into what many legal scholars now refer to as a tactical sword. To see this in action, imagine a man named Christopher in the current year 2026, looking back at the records of his own father's divorce in 2012. Christopher's father was a middle manager with a clean record, yet he found himself a victim of the ex parte revolution. The term ex parte is a Latin legal phrase meaning for one party. In the context of a 20th century U.S. divorce, it meant that a spouse could walk into a courthouse, fill out a standard form alleging fear or harassment, and receive a judicial order without the husband ever being present to defend himself. Step by step, the process was designed for speed over accuracy. The judge, often seeing dozens of these petitions in a single morning, would err on the side of caution. Within minutes, a temporary order was signed. The first time the man would hear about it was when a deputy arrived at his place of employment or his front door to serve the papers. For the American man, this was the beginning of what sociologists call civil death. Historical trends show that the impact of these orders extended far beyond a simple stay-away command. The moment the order was served, a cascade of automated consequences was triggered. Imagine the scenario. Christopher's father is served at 3 p.m. on a Friday. Under the terms of the temporary order, he is immediately barred from his own home. He is given 15 minutes to gather his essentials while a police officer watches him. He cannot take his computer, his files, or even his children's photos if the order specifies no contact. More importantly, under the Federal Brady Act of 1994, he is immediately prohibited from possessing a firearm. For men in the military, law enforcement, or the private security sector, this meant an instant, unpaid suspension from their careers. Their professional reputation was dismantled before they ever had a chance to speak in front of a judge. The data behind this phenomenon is staggering. By the late 1990s, the number of restraining orders issued in the United States had skyrocketed into the millions annually. Case studies from this era suggest that in high-conflict divorces, the filing of a temporary order of protection became a standard opening move for many litigators. The goal was not always safety. Often the goal was the immediate seizure of the status quo. In a custody battle, the parent who remains in the family home with the children holds a massive psychological and legal advantage. By using an ex parte order to remove the father, the opposing side established a new reality where the mother was the sole caregiver. When the actual hearing finally occurred weeks later, The court was often reluctant to move the children back and forth, effectively handing the mother primary custody based on a temporary allegation that had never been cross-examined. As we moved into the 2010s, the definition of what constituted domestic violence began to expand in many U.S. jurisdictions to include non-physical categories like coercive control or emotional distress. While these laws aim to address the complexities of domestic life, in the hands of a strategic litigant, they became incredibly broad. Historical trends show that a man could be served with an order for simply sending too many emails regarding his children's medical appointments, or for raising his voice during an argument about finances. The potential outcomes for men became increasingly binary. You either had a perfectly clean record, or you were a persona non grata in the family court system. Men during this period had to develop a sophisticated defensive posture just to survive the initial filing phase of a divorce. This led to the rise of the documentation era. Case studies of successful outcomes for men in the early 2000s almost always involve a high level of digital archiving. Men began to keep voice recorders running during every exchange of the children. They moved all communication to apps that could not be edited or deleted. They stopped entering the family home even for a moment, insisting on exchanges in public, well-lit areas under the gaze of security cameras. This was the birth of parallel parenting, a strategy where the two parents operated as completely separate entities with zero direct contact, a far cry from the co-parenting ideals of the 1980s. The financial industry surrounding these orders also played a role. Under the Violence Against Women Act (VAWA) and subsequent state funding models, many domestic violence agencies received federal grants based on the number of clients they served and the number of orders they helped facilitate. This created a system where there was significant institutional pressure to encourage filings, even in cases where the evidence was thin or non-existent. For the American man, this meant he wasn't just fighting his spouse. He was fighting an entire state-funded infrastructure that viewed him as a potential threat by default. The step-by-step psychological toll of this era cannot be overstated. Imagine the internal state of a man who has done nothing wrong, yet finds himself sleeping on a friend's couch, unable to see his children, and labeled a domestic abuser on a public record that any future employer can find. This led to a crisis of male suicide and depression during the early 2000s that was often ignored by the mainstream media. Men felt that the legal system had become a trap where the truth was secondary to the narrative. They were living in a world where the preponderance of evidence standard, meaning 51% likelihood, was used to strip them of their most fundamental constitutional rights. By 2026, we see the long-term results of these 20th century legal shifts. The generation of children who grew up during this era of tactical litigation often have fractured relationships with their fathers, not because of anything the father did, but because of the legal wall that was built between them during the formative years of the divorce. Men learned that in the American courtroom, the best defense was a total lack of engagement. They became the gray rocks we discussed earlier, stripping themselves of personality and emotion to avoid providing the slightest spark that could be fanned into an allegation of harassment. But even as men mastered the art of the psychological defense and the digital archive, the battle was shifting once again. The late 20th century ended with the battle for the children and the home, but the 21st century opened with a war over the very foundation of a man's future: his wealth. As we move into the next part of this masterclass, we are going to look at the transition into the era of the high net worth divorce. We will examine the data behind the rise of the forensic accountant and the new strategies used to divide assets that didn't even exist 20 years ago. What happens when the court decides that your future earning potential is a marital asset that can be sold? How did the rise of digital currency and global markets create a new, high-stakes game of financial hide-and-seek? The era of the digital asset war was about to begin, and the tactics used to bankrupt a man in the 2010s are about to be revealed. As the sun set on the 20th century, the battleground of American divorce shifted from the bedroom and the kitchen to the ledger and the server. If the 1970s were about the right to leave and the 1980s were about the right to parent, the 1990s and early 2000s became an era of total financial transparency and the valuation of the intangible. To understand the financial gauntlet that Christopher's father and his contemporaries had to run, we must look at a landmark shift in how the United States legal system defined property. Imagine a man named Thomas in 1995. Thomas is a successful surgeon in New York who spent 10 years in grueling residency and fellowship programs. His wife supported the household during those lean years. When they divorce in the mid-90s, Thomas is shocked to learn about a legal precedent that had been simmering since the mid-1980s. the valuation of a professional license as marital property. This was the era of the O'Brien versus O'Brien legacy. In 1985, the New York Court of Appeals made a radical decision that would echo through the next 2 decades. They ruled that a medical license, a piece of paper representing a man's future ability to earn, was an asset that could be appraised and divided. For Thomas, the step-by-step reality was terrifying. A forensic accountant was hired to perform a projected earnings analysis. This was not about the money Thomas had already made. It was about the money he was expected to make over the next 30 years. The accountant calculated the difference between what Thomas would earn as a surgeon and what he would have earned with a basic college degree. They then took that massive number, discounted it to its present value, and determined that a significant percentage of Thomas's future career belonged to his ex-wife. This was the first time in history that a man's potential, his very intellect and future labor, was treated like a house or a car that could be liquidated. Historical trends during the 1990s show this concept of enhanced earning capacity spreading into other sectors. It wasn't just doctors. CEOs with MBAs, lawyers with prestigious partnerships, and even celebrities with brand recognition found their career goodwill under the microscope. Case studies from this era highlight the rise of the double dip. This occurred when a court would value a man's business as an asset to be split in the property division, and then use the same income from that business to calculate his alimony and child support obligations. For the American man, this felt like being asked to pay for the same pie twice. The potential outcomes were often financially ruinous, leaving high-earning men with a lifestyle that was a mere shadow of their former success, despite their continued high productivity. As we move toward the current year of 2026, we can see how the 1990s also perfected the art of the forensic audit. Step by step, the discovery process became an exhaustive hunt for the lifestyle gap. Imagine Thomas trying to explain his finances in 1998. The forensic accountant wouldn't just look at his tax returns. They would perform a lifestyle analysis. They would catalog every dinner out, every vacation, and every luxury purchase over a 3-year period. If Thomas's reported income was $200,000, but his expenses suggested a $300,000 lifestyle, the court would assume he was hiding income. This led to the era of the imputed income. Even if Thomas couldn't find the money, the court would act as if it existed, setting support levels that were impossible to meet. Historical data suggests that this period saw a massive spike in men filing for bankruptcy following a divorce, as the gap between their court-ordered obligations and their actual cash flow became unbridgeable. This was also the era when the Qualified Domestic Relations Order, or QDRO, became a household term for the American man. Following the Retirement Equity Act of 1984, the 1990s saw the full implementation of the carving up of the American pension. Before this, a man's retirement was his own. It was his reward for 30 years of labor. But the new legal landscape viewed retirement funds as deferred compensation belonging to the marriage. Step by step, men watched as their 401ks and IRAs were split down the middle. In many cases, using formulas like the Majoska's formula, the court would determine that the ex-wife was entitled to a portion of the pension based on the number of years the marriage overlapped with the man's employment. This meant that a man retiring in 2015 would see a check from his employer diverted to an ex-wife he hadn't seen since 1992. The long-term financial planning of the American male was effectively nationalized by the family court system. As the decade turned and the early 2000s brought the digital revolution, the game of financial hide-and-seek became high-tech. Thomas's younger counterparts in 2005 were dealing with the first wave of offshore digital banking and the complexity of stock options. Companies began offering executive compensation packages that were designed to be deferred or contingent, partly as a response to the aggressive divorce laws of the time. But the legal system evolved just as quickly. Courts began to use the concept of a constructive trust. If a judge believed a man was intentionally diverting assets to a third party or an offshore account to keep them out of the divorce, the judge could essentially freeze those assets or award the wife a larger share of the remaining domestic assets as a penalty. The transparency was becoming absolute. The historical trends of the 2010s added yet another layer: the digital asset. As we approach 2026, we look back at the first men who tried to hide wealth in early cryptocurrency or virtual real estate. They discovered that while the blockchain was decentralized, the subpoena was not. Forensic experts learned to track crypto wallets and digital transactions with the same precision they used for bank statements. The American man found that there was no longer any corner of the financial world where he could find privacy. Every transaction was a trail, and every trail led back to the divorce court. But perhaps the most significant financial shift of the late 20th century was the transition of alimony from a moral punishment to an economic equalizer. In the 1950s, you paid alimony if you were a bad husband. In the 1990s, you paid alimony to maintain the standard of living established during the marriage. This was the era of the Permanent Alimony Award for long-term marriages. A man who had been married for 20 years could find himself paying for his ex-wife's lifestyle for the rest of his life, regardless of her ability to work. This created a massive disincentive for high-earning men to ever retire. They became what sociologists called the silver-haired workforce, men in their 70s still working high-stress jobs because their court-ordered obligations were based on their peak earning years. The step-by-step destruction of the man's financial autonomy was nearly complete. He had lost his future earnings through license valuation, his current earnings through imputed income and lifestyle audits, and his past earnings through the QDRO and pension splits. He was a man who worked for the state, for his children, and for his ex-wife, often in that order. The 20th century had transformed the American man from the master of his house to the primary funder of a dissolved one. But as the financial war reached its peak, a new question began to emerge in the minds of men across the United States. If the system was this efficient, this invasive, and this costly, was the traditional model of marriage even viable anymore? This leads us to the final chapter of our deep dive masterclass. We are about to enter the era of the countermove. We will examine the rise of the prenuptial agreement as a standard requirement for the modern man, the emergence of the MGTOW movement as a sociological response to these laws, and the final synthesis of the 20th century experience. How did a century of legal defeats lead to a new kind of empowered, cautious, and strategically minded American man in 2026? The conclusion of this history is not just about what happened, it is about how the American male identity was forged in the fires of the family court. You are about to see the final pieces of the puzzle fall into place. The final pieces of the puzzle fall into place when we examine how the American man transitioned from being a passive subject of the law to an active architect of his own domestic fate. By the late 1990s, the psychological and financial exhaustion of the previous decades had birthed a new era of strategic defense. This was the era of the prenuptial agreement, once a tool reserved for the Gilded Age elite, now becoming a standard requirement for the middle-class professional. To see this transition, imagine our character Christopher in the current year 2026. Christopher is 35 years old, and he is considering marriage. Unlike his grandfather in 1955, who viewed marriage as an immutable social contract, or his father in 1995, who viewed it as a high-risk gamble, Christopher views it as a structured legal partnership. Before he even considers a ring, Christopher engages a lawyer to draft a document that explicitly opts out of the default state laws we have spent this masterclass deconstructing. The historical trends of the early 2000s show that prenuptial agreements began to double in frequency every 5 years. This wasn't just about protecting existing assets. It was about neutralizing the specific 20th century legal traps we discussed in earlier parts. Modern agreements now specifically address the valuation of professional licenses, the definition of separate property, and even the waiver of alimony in certain conditions. Step by step, men began to realize that if they did not write their own rules, the state of New York, California, or Texas would write them on their behalf. The potential outcomes of a divorce in 2026 are often decided years before the wedding ever takes place, moving the power back from the judge's discretion to the party's original intent. But the 20th century didn't just change the paperwork, it changed the legislation. As we reached the conclusion of the 1900s, the fathers' rights movement matured from a collection of angry support groups into a sophisticated lobbying machine. Case studies from states like Kentucky and Arizona show a radical shift in the 2010s toward a presumption of 50-50 shared parenting. This was a direct counterstrike against the tender years doctrine that had marginalized men for decades. Historical data reveals that when states moved to a default of equal parenting time, the rate of high-conflict litigation dropped significantly. Men learned that the best way to win the game was to change the rules of the court itself. They lobbied for transparency in child support calculations, and for the right to an accounting of how those funds were actually spent. This was the professionalization of fatherhood, where men demanded the same legal standing as mothers, not as a favor, but as a constitutional right. We also have to look at the massive sociological response known as the marriage strike. To understand the depth of this shift, consider the data. In 1960, roughly 72% of all American adults were married. By 2026, that number has plummeted to below 50% for the first time in United States history. For many men, the history of the 20th century served as a cautionary tale. They saw the alimony jails of the 50s, the no-fault wipeouts of the 70s, the custody wars of the 80s, and the digital surveillance of the 90s, and they simply decided to opt out. This led to the rise of the cohabitation agreement, where men live with partners but maintain entirely separate financial identities. This is the ultimate defensive posture, the refusal to enter the jurisdiction of the family court altogether. Step by step, the American man in 2026 has become a legal minimalist. He is more likely to engage in mediation or collaborative law than the scorched earth litigation of his father's generation. Collaborative divorce, which emerged as a trend in the early 2000s, requires both parties and their attorneys to sign a contract stating they will not go to court. If the process breaks down and they do go to court, both attorneys must resign. This created a powerful financial incentive for resolution. For the man of the 21st century, this is the final lesson of the 20th. The only people who truly win a high-conflict divorce are the ones billing by the hour. By choosing mediation, the modern man bypasses the psychological evaluations, the forensic audits, and the tactical restraining orders that defined the previous century. As we conclude this deep dive masterclass, we must reflect on the journey. We started in 1900 with a world of staged hotel room scandals, and ended in 2026 with a world of digital assets and prenuptial shields. The American man has been forced to evolve from a provider who assumed the law would protect his role, to a strategic litigant who knows the law is a neutral and often cold administrative machine. The history of divorce help for men is not a story of easy answers, but a story of hard-won knowledge. Every law on the books today is a scar from a battle fought by a man in the 1940s, the 1970s, or the 1990s. You now have the context to see the system for what it is. You understand that the child support enforcement complex was a response to the welfare reforms of the 90s. You know that the move toward joint custody was a hard-fought victory against a century of maternal preference. You recognize that the digital trail you leave today is the evidence of tomorrow. This historical perspective is your greatest asset. It allows you to move with intention rather than emotion. The 20th century was a gauntlet that reshaped the American family, and while the costs were high, the result is a generation of men who are more informed, more cautious, and more dedicated to their children than perhaps any generation before them. But the story doesn't end here. As we look toward the next decade, new challenges are emerging on the horizon. The rise of artificial intelligence in legal discovery, the total globalization of assets, and the shifting definitions of the family unit itself are already beginning to create the 21st century's version of the divorce trap. What happens when an algorithm decides your parenting schedule? How do you protect your legacy in a world where the state's reach is even more absolute than the federal databases of the 1990s? The history we have covered is the foundation, but the future of the American man in the domestic arena is still being written. We are entering a phase where the battle moves from the courtroom to the very definition of what it means to be a man in a society that no longer requires traditional marriage to function. In our next series, we will dive into the specifics of the 2020s legal revolution, the rise of the gray divorce, the impact of remote work on jurisdictional battles, and the new strategies for asset protection in the age of decentralized finance. You've seen how we got here. Now it's time to see where we are going. The masterclass continues in our next deep dive into the modern era of risk management and the future of the American male.